This unit is the ICF code anchor for Module 8, the place where the payment infrastructure you have been configuring meets the ethical framework you operate inside as a credentialed coach. The CC1 and CC3 work lands here, with ICF Code Standards 4.2 and 4.3 cited by section and verbatim text. The composite case at the end makes the failure mode concrete, and the policy design walks the deposit, cancellation, rescheduling, and no-show clauses one at a time. Deposit and cancellation policies are not a legal formality you tack onto an engagement agreement at the bottom. The ICF says so explicitly. The coaching agreement definition in the code's appendix lists payment terms and cancellation policies as required elements of the agreement, alongside scope, confidentiality, duration, and the other structural pieces you would expect to see named there. Which means the design of these policies is an ethical question before it is a business question, and the design choices map directly back to the core competencies, specifically CC1 on ethical practice and CC3 on establishing and maintaining agreements with the client. Standard 4.2 is the first hinge between cash mechanics and ethics, and most coaches read past it because the language sounds clinical. The standard names personal limitations and circumstances that may impair performance, and the working interpretation in this unit is that financial pressure from absorbed cancellations sits inside that category. If 3 no-shows in a month erode the rent buffer, the next intake call carries financial weight the client never agreed to. The standard requires you to recognize that pressure and structure your way out of it. A deposit policy is one of the structural answers, not a customer service preference. Code Standard 4.3 follows in the same section and connects to the cancellation policy in a parallel way. The standard text reads, "Remain alert to indications that there might be a shift in the value received from the coaching relationship and discuss this with the client. And if appropriate, explore changes in the coaching relationship or the potential for a different coach, professional, or resource." A cancellation policy that is buried in fine print, ambiguous on the rescheduling case, or visibly one-sided creates the exact conditions where a value shift dispute starts forming. Standard 4.3 then requires you to spot the dispute early and address it with the client. A clear policy prevents the dispute from forming in the first place. CC 3.3 is where deposit policy actually becomes a competency obligation, and the citation matters more than coaches usually treat it. Subbehavior 3.3 lists logistics, fees, scheduling, duration, termination, confidentiality, and inclusion of others as the specific parameters that have to be agreed at the start of the relationship. Deposit and cancellation terms live inside fees and scheduling. They are not bolt-ons. CC1 then closes the loop by requiring the agreement be guided by standards 4.2 and 4.3, which means the policy design has to point back to the code, not to whichever template the coach grabbed during onboarding week. The ethical test that both standards point toward is simple, and it is not about protection. Of course, the policy should protect your time. That is a legitimate purpose of designing it at all. The deeper test that both 4.2 and 4.3 require you to pass is, could my client clearly understand what they agreed to before they signed it? Clarity and transparency before agreement, not buried terms revealed at the moment of dispute. The protection function and the clarity function are not in tension for most clauses. The clauses that pass the clarity test are also the ones that protect you most durably, because the client cannot later claim they did not know. Deposit norms cluster in a working range, and the design choice inside that range is yours. 25 to 50% of the total engagement fee at contract signing for package engagements, 3-month containers, 6-month containers, named deliverable projects. For per-session engagements where there is no package, a session in advance deposit is the common pattern. The client pays for next week's session at the end of this week's. The exact percentage you settle on is a business decision driven by your cancellation history, your typical engagement size, and your client population. The ethics requirement attaches to disclosure, not to the percentage itself. The client sees the number before they sign. Cancellation window length is a design choice with no objectively correct answer. 24-hour, 48-hour, and 72-hour windows are all in common use across the coaching industry. The 24-hour window offers maximum client flexibility, but it also means a cancellation at 10 in the evening for an 11 the next morning session costs you the slot with zero ability to rebook. The 72-hour window protects your calendar more durably, but creates friction for clients whose schedules are genuinely volatile, like executives whose travel changes weekly. Neither window is right or wrong on its own. The one you will not enforce when it matters is the wrong one. Rescheduling and cancellation are two different events, and the policy language treats them differently. Distinguish the two explicitly in the clause itself, because if you do not, every cancellation arrives in your inbox framed as a rescheduling request, and the policy loses its teeth. The common standard reads, 1 reschedule per engagement period with 24 hours plus notice does not forfeit the session fee. Cancellation inside the window forfeits. Without that distinction in writing, you spend the next year arbitrating whether each missed session was a cancel or a reschedule, and most of those arbitrations end with you eating the cost because you did not name the difference up front. The no-show case is the cleanest, and 3 sentences of policy language prevent a recurring negotiation. The client does not appear at the session time. No notice was given. No rescheduling email arrived. You sat in the virtual room for 15 minutes. The cleanest answer is full session fee billed, which the clause states directly. Coaching sessions missed without notice are billed in full. 3 sentences in the engagement agreement, signed at engagement start, and the question before it ever surfaces. Their absence means you negotiate the no-show outcome with every client who has one, every time it happens, with no contractual ground to stand on. Dana's case shows the cost of skipping the agreement work, and the cost compounds in 2 directions at once. 5 sessions in, the client disengages and the agreement has no forfeit clause, no deposit on file, and no scheduling default language. The invoice goes out and the dispute starts, but the dispute is the second event. The first event was a value shift that should have surfaced as a contracting conversation at session 3. Standard 4.3 names exactly that moment, and Dana has no anchor for the conversation because the agreement never had one. The policy gap creates the invoicing gap, which creates the relational rupture. The deposit and cancellation policy would not have prevented every difficult conversation in the Dana case, but it would have changed the shape of all of them. Deposit at contract signing. Different economics on the engagement. 25 to 50% of the package fee already paid. Clear cancellation policy inside the signed agreement. Expectations set on day 1 about what happens when sessions stop happening. No-show clause. No dispute over the value of session 5 because the agreement names the answer. The policy does not prevent difficult clients or difficult conversations. It turns a dispute in the dark into a dispute against a signed agreement that both parties read together at the start. That signed agreement is what CC3 requires Dana to have built. Attorney review enters when the policy language meets the jurisdictional reality. A deposit and cancellation policy is a contract provision, and contract provisions live or die in specific state law. Corporate clients with their own counsel reviewing your agreement before they sign. Coaching practices in states with unusual consumer protection rules that govern personal service contracts. Clients in jurisdictions where the cancellation language has been litigated. All three situations warrant the attorney from Module 3.4 reading the clause language before it goes into a signed agreement. This unit teaches the policy design at the methodology level. The attorney tells you whether the specific wording holds in your state. Read your draft policy from the client's side before you finalize anything in it. Sit down with the document, pretend you have never seen it before, and read each clause as if you are the prospective client signing the agreement for the first time. If any clause surprises you, that clause will surprise your client at the moment of dispute. And surprise at the moment of dispute is exactly what standards 4.2 and 4.3 and CC3 are written to prevent. The clauses that pass the client perspective reading are the ones that earn their place in the agreement. The clauses that surprise even you on a cold read get rewritten until they do not. Map each clause in the final policy to a specific anchor in the ICF code framework. Standard 4.2, Standard 4.3, or the Coaching Agreement Appendix definition. Every clause in your policy should connect to at least one of those three. The mapping table goes into the founding pack you will assemble in Module 20, and the act of doing the mapping forces you to remove any clause that exists only for convenience and not for a coaching agreement reason. Run the client perspective pass first, then run the code mapping pass second, and the policy that survives both passes is the one that earns its place in your engagement agreement and your professional practice. One closing note that the code itself makes load-bearing. The coaching agreement definition in the ICF Code Appendix lists payment terms and cancellation policies as elements of the coaching agreement by name, alongside scope and confidentiality and the other structural pieces. These are not optional add-ons appended after the substantive agreement is in place. They are part of what you and the client agree to at the beginning of the engagement, and CC3 requires that agreement to be clear, co-created, and understood by both parties. Design your deposit and cancellation policy that way from the first draft, and the rest of the unit's work falls into place around it.